afternoon, everybody. Good afternoon. For those of you who don't know me, I'm Jim, and I am the Dean of the University of Colorado Law School. It's my pleasure to welcome you all to the final round of this year's Rothgerber Moot Court competition. In 1951, Ira Rothgerber Jr. established this annual appellate moot court competition in honor of his father, the late judge and Colorado Law graduate Ira Rothgerber Sr. And you can learn more about Judge Rothgerber's impressive legal career in your programs. For more than 6 decades, this has been the premier moot court competition at the law school, providing students an opportunity to showcase their outstanding appellate advocacy skill. This year, 24 students competed in opening rounds with briefing of the problem. This was our largest group entering the competition in many years. Students advancing out of the opening rounds then participated in multiple preliminary rounds of oral argument. And I'm told the competition was quite stiff. And then there were 4. We congratulate this year's top 4 finalists: Hannah Bustillo, Alex Curvin, Shane O'Connor, and Hannah Reagan-Smith. And we wish you each good luck in the arguments today. It is certainly an honor to be a finalist, but we also want to congratulate all 24 of the students who entered the competition. You all do yourselves well to enter and participate in competitions like this one, and the experience that you gain through the competition will certainly serve you well through your careers and indeed through life. We are proud of each and every one of you who participated in the competition. Part of the rich tradition of this competition is the distinguished panel of judges that are assembled each year to judge the final round, or the final. This year we are honored to have 3 outstanding judges: Colorado Supreme Court Justice William Hood, who will be the presiding judge this afternoon. Also Judge Harris Hartz of the 10th Circuit Court of Appeals, and our newest Colorado Supreme Court Justice, Melissa Hart, who is still known around here as Professor Hart. We look forward to watching the spirited questions that will no doubt come from the bench, and we look forward to greeting and welcoming each of the judges at the reception that will follow the argument in the Rothgerber room of the library. I'd like to also recognize and thank the law firm of Willow Trigg O'Donnell for their sponsorship of the various events surrounding the Rothgerber Moot Court competition, and thanks especially to past Rothgerber finalist and partner at Willow Trigg, Hugh Gottschalk, for his continued support of the law school and for this competition in particular. Finally, I would like to recognize all former Rothgerber competition alumni who are with us here for today's oral argument. I'd like to ask all those former competitors in the Rothgerber competition to please stand. It's really an honor to have all of you, each one of you, back for this competition. We thank you all for your attendance here today. And with those words, I'd like to call on the bailiff to bring in the court.
All rise. The United States Supreme Court is now in session. Justices Hood, Hartz, and Chief Justice Hartz presiding.
Thank you. Please be seated. So I should just let you know that I've actually been called upon to preside, and I'm Justice Hood, not Judge Hartz. So let me just first call the case. The court calls the case of Dragontown University Petitioner versus Dr. Peter Foster, Respondent. May I have entries of appearance starting with the petitioner, please?
Alex Curvin, Your Honor, representing the petitioner on the 14th Amendment issue.
Hannah Regan-Smith, representing petitioner on issue 2.
All right, thank you. And for the respondent?
I'm Hannah Bustillo. I represent the respondent for the 14th Amendment issue.
Shane O'Connor, Your Honors, on behalf of the respondent, arguing the First Amendment issue.
All right, well, welcome to all of you, and let me just admonish all counsel that you'll need to keep track of your own time. My understanding is that you've been allotted a half an hour to each side. You've been advised that contrary to how it's worked in some of the other portions of the competition, that we're going to go petitioner, petitioner, and then do respondent, respondent. Petitioners can save time for rebuttal, but you'll need to keep track of your own time, essentially. Does everybody understand?
Yes, sir.
Okay. All right, so unless there are any other preliminary matters, we're ready to begin. The petitioner may begin whenever he's ready, whenever it's ready.
Mr. Chief Justice, and may it please the court. My name is Alex Curvin, and I will be representing the petitioner, Dragontown University, on the 14th Amendment issue. My co-counsel, Ms. Hannah Regan-Smith, will be representing the petitioner on the First Amendment issue. Your Honors, public universities are one of the bedrocks of our democracy. For over 2 centuries, they have produced educated citizens from all walks of life. In an era when the very nature of the truth is under attack by things like fake news and alternative facts, we rely on public universities to provide guidance. Now, public universities cannot provide that guidance if they lack integrity. For a public university, integrity means more than just the strength of its faculty, its teaching, and its research. It means the ability to take action when that integrity is at stake. Now, in this case, Dr. Peter Foster and his ideas regarding the treatment of epilepsy were front and center in a local doctor's malpractice trial. There were students protesting on campus. A major donor threatened to withdraw funding, and concerned alumni from the medical school beseeched the school to terminate Dr. Foster's employment. Now, Dean Stephanie Berman of the medical school wrote Dr. Foster and said that they need to meet to discuss the allegations against him, and he did not respond for 17 days. Dragontown University then terminated him. Now, Dr. Foster alleges that Dragontown University deprived him of a liberty interest under the 14th Amendment. The district court dismissed that claim, only to be reversed by the 14th Circuit. The petitioner, Dragontown University, respectfully requests that this court reverse the 14th Circuit for the following reasons. First, Dr. Foster failed to plead sufficient facts to show that he was deprived of a liberty interest. And second, he failed to plead sufficient facts to show lack of a constitutionally adequate notice and hearing. Now, beginning with the first issue, this court has held in Roth that in order to prevail under the 14th Amendment, a plaintiff must show 3 things. 1, a constitutionally cognizable liberty interest. 2, a deprivation of that interest. And 3, lack of a constitutionally adequate notice and hearing. Now, in this particular case, Dr. Foster alleges that Dragontown University deprived him of his liberty interest and his reputation. Now, following this court's holding in Paul versus Davis, stigma to one's reputation is not sufficient to invoke the 14th Amendment. Rather, the plaintiff must show what's been known as stigma plus. That is, stigma to their reputation plus the loss of another government right or benefit. Now, focusing on the stigma element, the circuits differ on the wording, but generally they hold that a plaintiff must show that the employer made statements that impugn their good character or reputation, that those statements were false, that those statements occurred during the course of termination, and that those statements were made public.
Let me jump in there. So the Second Circuit took a different approach on that issue. And I realize you argue against that in your brief, but if we were to adopt the approach by the Second Circuit in the Donato decision, does that mean that you lose on stigma?
Not necessarily, Your Honor. If we look at some of the statements that were made here, and again, I want to draw attention to this court's decision in Roth. This court suggested that stigmatizing statements involved allegations of dishonesty or immorality. Now, if we look at the statements at issue in this case, for example, the the university in its press release said that it fired Dr. Foster because he disseminated advice inconsistent with its standards. If we look at what the Eighth Circuit has said in Mercer, if we look at what the Ninth Circuit has said in Raleigh, these aren't charges of immorality or dishonesty.
Well, shouldn't we be considering the letter that was attached?
It was attached, and you should be considering it. But even those statements don't label Dr. Foster as someone who's immoral, someone who's
Just
dishonest.
insane. Just insane.
They labeled the statements as insane. And looking at the one definition of insane is outrageous. If we look at the previous sentence, it says that his advice was outdated, irresponsible, and outrageous. Then it says the statements
Shouldn't
were
he have had
insane.
an opportunity to talk to these people, have a hearing where he can explain that this was not an outrageous statement?
Well, in order to do that, Your Honor, he has to allege that those statements were false. Now, the other part, so to get back to your question, Your Honor, assuming you follow the Donato holding from the Second Circuit, arguably, yes, we lose on the stigma part. But, or we lose on the stigmatizing statement part. But Dr. Foster also has to show that those statements were false. As this court has held in Codd versus Velger, a plaintiff is only entitled to a name-clearing hearing if he is challenging the veracity of the evidence against him, if he is challenging the nature of the allegations against him.
Well, okay, that takes us to Justice Hartz's point, then. I guess you were Justice today. And so Justice Hartz's point about the insane being something that is perhaps plausibly false under a 12b6 standard. Why isn't that enough for falsity?
Well, what this court, so, Your Honor, I want to start with what this court has, with this court's history in looking at defamation. So, for example, in Hustler Magazine versus Falwell, a plaintiff needs to show that a statement is it's a false factual statement. Also, what this court has held is in Bressler is that we need to read the statement in context. And so to go back to the alumni letter, it first says that his medical advice was irresponsible, that it was outdated, and that it was outrageous. Now, in the parlance of our time, insane can mean outrageous. And so one reading of that could be that the statements are not challenging Dr. Foster's sanity, rather they're just saying that the statements that he made were outrageous.
Why should we insist that the statement be false? It seems to me if someone states an opinion, which may not be objectively false, but it's so damaging to people, so damaging to the victim, that it would make it very hard for him to be employed. It would ruin his reputation, just the fact that the university has such a poor opinion of him. And when it's an opinion, a hearing could be much more useful. He could explain why this wasn't outrageous. Why shouldn't he be entitled to a hearing before his government employer disseminates an opinion that's so damaging to him?
Well, if we were to follow that holding, Your Honor, or follow that logic, first it contradicts what this court has held in Paul versus Davis, in Roth, in all of its decisions, that these statements have to be defamatory, so that they have to be false. On the other hand, I think that it would be creating a significant burden for government employers, because if they're going to release a statement accusing somebody of this kind of incompetence, they are going to be forced to consider giving a prophylactic hearing or something like that.
And that's so terrible? To give a guy a chance to explain himself?
It's not that it's so terrible, Your Honor, but we also have to consider what the government's interest in this too. And in this case, Dragontown University provided Dr. Foster with some notice, and he didn't respond for 17 days.
That's a different issue. You were arguing that there's no notice at all required. Now you're reverting to whether there was adequate notice here. You're giving up on the other argument, at least for now?
No, I'm not, Your Honor. I'm not, Your Honor. When thinking about, is it bad to give him a hearing? No, not necessarily no. But again, I think that we have to focus on the nature of the statements here. And these statements, yes, they might have been aggressive. They might have damaged his reputation. But again, this court has held and the circuit courts have held that those sort of statements need to be false. If there's no falsity in the accusations, there's really no need for a hearing.
Counsel, you point out that one interpretation of the word insane could be outrageous. Another interpretation of insane could be mentally ill to a point of insanity. Why at the 12b6 stage should we assume, or should the courts assume, that insane in this context means outrageous rather than mentally ill to the point of insanity, which I think is probably false?
Because the letter said that these statements were insane, not that Dr. Foster himself was insane. So, and again, when read in the context, if we look at the previous sentence where it says that the alumni consider his advice to be outrageous, irresponsible, outdated, it seems to make sense that in the next sentence they would highlight that by the outrageous part of it by saying that these statements were indeed insane, outrageous.
Let's go back to the notice point. Dean Berman's email was kind of vague. Didn't your client have an obligation to more expressly advise Dr. Foster of the opportunity for a name-clearing hearing?
So, Your Honor, looking through the case law, there really is nothing that suggests that the notice itself was adequate. I am going to concede that. But if we look at what the other circuits have held, such as the Fifth Circuit, the 11th Circuit, the First Circuit, the Second Circuit, they hold that the damage comes when the plaintiff requests a hearing, and then that request is then denied. In this particular case, looking at Dr. Foster's complaint, nowhere did he say that he requested a hearing and was denied. Nowhere does he say that he was not aware that he couldn't request a hearing. And so in that case, the notice may have been inadequate, but Dr. Foster's claim still should fail because he did not himself request a hearing and have that request denied.
You're asking us to presume that he knew that he could request a hearing?
Well, Your Honor, in Quinn versus Sheary, the Sixth Circuit upheld a 12b6 dismissal where the plaintiff did not allege that he was unaware that he had a right to a hearing. And to get back to Dean Berman's email, while that email may not have been sufficient constitutionally sufficient in that regard, it was certainly sufficient enough to suggest to Dr. Foster that something was afoot. They email him, they tell him that he needs to respond. I mean, in the complaint, nowhere does he say that he didn't receive the email. Nowhere in his complaint does he say he wasn't aware of it. And he did not respond for 17 days. His job was at stake, and he did not respond for 17 days. Certainly he knew that something was going on. And after he was terminated, certainly he knew that he could have protested. Now, what the Sixth Circuit has talked about in Winskowski versus City of Stephen is the reason why a plaintiff should have to request this kind of hearing is it prevents this sort of thing from happening. Someone like Dr. Foster for not requesting a hearing, lying in wait, and then filing some sort of action. Why it would be better for him to go to the university and say, you terminated me, I want a chance to clear my name. And if Dragontown University denied him that opportunity, then yes, there is a violation of the 14th Amendment. But until then, I don't see grounds for a violation. So, Your Honors, for the foregoing reasons, Dragontown University respectfully requests that this court reverse the 14th Circuit and reinstate the district court's dismissal.
Mr. Chief Justice, and may it please the court. My name is Hannah Regan-Smith, and I am arguing issue 2 on behalf of petitioner to this case, Dragontown University. At issue before the court is the question of whether public universities should retain the ability to ensure that the speech of their faculty members meets the prevailing standards for quality, integrity, and professionalism.
So the university decides whether what the professor says is true, and if it doesn't think it's true, they can terminate him?
In this particular case, that's not at issue because there is evidence in the record, the facts which were stipulated to by both parties, that there is widespread agreement in the medical community that Dr. Foster's speech had no basis in medical science.
And if there's widespread belief of something, that's enough?
In the context of medical advice, that certainly seems to be a sensible benchmark.
It's not in other areas? I mean, where are you going to draw the line? If he were an economist, it would be different, or a political scientist?
In this particular case, the speech at issue is verifiably false and dangerous. In the context of an economist, I believe it would be more difficult to determine that speech is necessarily dangerous or verifiably false.
What about physics? If it were a statement in physics, that's verifiably false?
In this particular case, a doctor took Dr. Foster's advice.
I'm asking, I'm trying to see the line here. When a university can decide that something is verifiably false. You know, when Einstein came to the United States after publishing his general theory of relativity, he was greeted with an affidavit, or excuse me, a petition by the 100 top physicists in the country saying that was wrong. So he could be fired by his university for saying something so silly?
Your Honor, not necessarily. In this case, the issue is that Dr. Foster, there's no indication that Dr. Foster supported any of his reasoning with sound scientific methodology, as opposed to in Einstein's case, he presented, in the example that you gave with Einstein, there are presented reasons to believe that those statements might be true. In this case, there is a scientific method that is developed and used to determine whether or not medical advice is sound. There are rigorous testing processes. In this case in particular, the advice related to how epilepsy should be treated. There are rigorous processes to determine what an appropriate method of treatment is.
Well, okay, there are different levels here. He didn't treat anyone himself. You're not saying he committed malpractice in treating a patient, right?
That's correct.
And he didn't teach this in a course to students, is that correct?
That's correct.
So he's speculating on his home website. Is there a difference there? Can you start raising questions in that context and not be fired if the question you raised is considered out of the mainstream?
Yes, I believe that there is plenty of space for professors to do that. That would be the case if Dr. Foster had limited his statements on his website to, for example, suggestions that additional grant funding should be spent on alternative treatment methods, or if he suggested that more practicing doctors, that more researchers should funnel their efforts into alternatives to pharmaceuticals. In this case, he advised doctors to pursue a course of treatment that has been proven to be dangerous. The university's ability to regulate that speech is of crucial importance for the university's continued reputation and function.
Ms. Regan-Smith, let me ask you to address your contention that this was within the scope of his official duties. I find that assertion troubling. Help me understand your perspective on that.
I think there are three compelling pieces of evidence that help us determine whether that the speech in this case was made pursuant to his official duties. The first is that Dr. Foster's formal job responsibilities included a directive that he engage in debate and foster discussion. The second is that Dr. Foster, in fact, understood his job to require that. And the third is that the speech in question fit into that description of the speech.
I understand that three-part analysis, but is there no room for consideration of the fact that this was a privately owned website? Doesn't that have some logical bearing on the answer to this question?
Not necessarily. The American Association of University Professors, which represents professors and considers itself a leading voice on issues of academic freedom and other matters of employment for professors, it believes, since its 1915 Declaration of Academic Independence, it has asserted that a professor's primary duty is to the public itself. That is held to be before the professor's duty to a university or to the students therein. So that conception of what a professor is doing, that a major part of a professor's job is engaging with the public, tends to support the idea that when a professor of medicine speaks on a topic of medical concern, he is actually speaking pursuant to his job responsibilities as a university professor.
So you're not hanging your hat on the fact that he used his work email address or that his bio referred to what he does for his day job?
Those facts do, I think, lend credibility to the finding that this speech was made pursuant to his official responsibilities. But the fact is that professors are expected to engage with the public, and that's what he was doing here.
Does that mean, so any time that he spoke about medical issues in any context, this would be pursuant to his official duties?
Your Honor, I believe that the more closely aligned the professor's speech is with his or her area of expertise, the more likely it is that he or she is speaking pursuant to the official responsibilities as a professor. In any event, even if this court were to find that Dr. Foster's speech were not made pursuant to his official duties as a professor, under Pickering balancing, it would still be the case that the speech in question is not protected by the First Amendment. Under Pickering balancing, the reviewing court generally looks first to the speaker's First Amendment interest in this speech at issue, and then looks to the interest in the government body and the extent to which the speech interfered with the government's ability to fulfill its mission to the public.
Well, let me stop you there. Your friends on the other side of the aisle say that what's really the focal point of the Pickering line of cases is workplace disruption. And they say this only resulted in a slight workplace disruption. You want to respond to that contention?
Your Honor, I believe that somewhat misreads Pickering. The purpose of Pickering is that government entities exist in order to provide services to the public. And sometimes that ability can be disrupted by interference with workplace harmony, the ability of supervisors to control their employees. But government entities exist to serve the public, and so that guides the proper inquiry into the extent to which the speech interfered with the government's interest. So in this case, a university has an interest that goes beyond maintaining harmony among professors or keeping a calm student body, for example. In this case, the university also has an interest in providing accurate, reliable, and safe information to the public. That's one of the things that universities exist to do. It also has an important interest, especially in the context of medical information and medical advice, in maintaining the public faith and trust in the university. We saw an analogous situation in this court's decision for San Diego v. Roe, in which the public faith and trust in police departments was critically important for the police department to be able to achieve its government mission.
What do you mean by this faith and trust of the public? That would cause wouldn't that excuse the university from punishing a faculty member for saying something that's out of the mainstream but maybe not objectively false, because people would think less highly of the university because faculty members are saying something that a large part of the public thinks is outrageous? Are you suggesting that would be an adequate reason?
I'm not sure that a university would as much be able to prove that that undermines trust in the university to the same extent as is the case here. For example, when people stop having faith and trust in medical institutions, we see incidences like the failure to vaccinate children being on the rise. So the university's interest in maintaining public trust, particularly in its medical school, is especially strong in this context. It might not be as strong in another context.
Okay.
So Dr. Foster's speech, because it was not accurate, not reliable, and was unsafe, did interfere with the university's interest in providing that type of information to the public. Furthermore, Dr. Foster's speech is generally considered low First Amendment value. Speech that is verifiably false and dangerous has never been understood to be protected under the First Amendment. The quintessential example is somebody yelling fire in a crowded theater. The government has been
What about the stolen valor case?
So in that case, there was no third-party harm that resulted.
Yeah, but it was objectively false, and it was protected by the First Amendment.
And that's the first time that this court has held that objectively false speech can be verified. I think it's crucial that in this case, Dr. Foster's speech was also resulted in third-party harm, or was at least involved in third-party harm. The court seemed particularly concerned in Alvarez, which was a four-judge plurality opinion, that the speech did not result in third-party harm. Additionally, in that context, the government was regulating as sovereign, and it is understood to have much more expansive powers when it does so than when it regulates in its capacity as an employer. As such, a case like defamation or libel, in which the government is certainly allowed to regulate in its capacity as sovereign, isn't exactly the same as what has happened here. The university is not arguing that a plaintiff would have a case in tort against Dr. Foster necessarily, but it is instructive when assessing the First Amendment value of Dr. Foster's speech. Additionally, the university has pedagogical interests in being able to assure its constituents that its current and future students that they will be receiving high-quality public education.
So I'm concerned, before you finish, I want to be sure, excuse me, that you address the question of where, if we ruled in your favor, we would have to come up with some kind of a test that would draw the line between statements that you say are clearly false and other kinds of academic statements that are controversial or outside of the mainstream. It seems like this could open up the opportunity for universities to get rid of controversial professors relatively easily. How would you have us avoid that?
So I think one coherent way that the court could do it is something like a rational basis test, where the court would generally defer to the opinion of a university, but if there is an indication that there's viewpoint-based discrimination, for example, if there's no indication that the professor plagiarized, or if the professor has proof that he or she used methods that meet the prevailing standards for quality, integrity, and professionalism, then this court would be concerned, as it is in cases where it suspects that animus is at play in the equal protection context. I would like to reserve the rest of my time for a rebuttal. Thank you.
Thank you. For the respondent? Please.
Mr. Chief Justice, Your Honors, and may it please the court. Before us is a case in which the government has unjustly and irrevocably attached a badge of infamy to Dr. Peter Foster. This court can and should consult its 14th Amendment jurisprudence to affirm the safeguarding value that procedure would have had in this case had the government actually respected Dr. Foster's due process rights here.
You say his reputation has been irrevocably damaged. He couldn't sue for defamation, could he?
A civil defamation case, Your Honor, would be markedly different in that it contemplates defamation between two private parties. Now, in this case, because the government has engaged in defamatory statements, we're actually contemplating what would be known as a Section 1983 case here. So someone acting under the color of law has defamed someone or harmed their reputation. So because Dr. Foster he has a cognizable claim under the stigma plus test here as my first contention, because the university deprived him of both his interest in his reputation as well as his interest in continued employment. And second, despite the fact that he had these clear constitutional interests at stake, the university failed to provide him the benefit of adequate procedure.
Well, didn't they invite him to respond to the allegations and he failed to do so?
Well, Your Honor, while they did invite him to respond to some allegations, and I'll get into this a little bit more later, but for now, suffice to say that that email, while it was sent to him and it expressed the university's interest in having some kind of conversation with him, it wasn't constitutionally adequate in giving notice to him of what interests were at stake here.
Well, respond to the contention that per the Fifth, Sixth, Eighth Circuits, that it's really his obligation, Dr. Foster's obligation, to request the hearing in the first place. Why shouldn't that be the rule?
Well, Your Honor, this court has actually never held that it's the plaintiff's responsibility or the interest holder's responsibility to request that hearing. In fact, it's been this court's explicit holding in Mennonite that it was incumbent upon the government here to afford the interest holder notice in both its means and its substance that was constitutionally adequate to inform him of what interests were at stake and what the government was thinking about doing here.
Would that be true even if he had actual notice of his right to request a hearing?
Yes, Your Honor. This court in Mennonite actually explicitly spoke to that same issue. So it said that even if a person has, due to the surrounding circumstances, pretty good reason to know of what the government is about to do to him, or if he's a sophisticated party with the ability to reasonably find out that his interests are at stake, it is still incumbent upon the government here. They are not relieved of their constitutional obligation to still afford Dr. Foster adequate notice here. It would be as if I went to a neighbor's house and knocked on their door, told them that I was suing them for trespass, and then expecting them to show up in court at the appointed day and time. Now, while that person might know that I'm putting them on notice that I don't like their trespassing abilities, it's still the fact that there are procedures here that I had to follow. The same here was true of the government.
What did the university have an obligation to put him on notice of precisely?
Yes, Your Honor. So there were two things, generally speaking, that the government had to do here. And they're both subsumed under the umbrella of what's called reasonably calculated notice under this court in Mullane. So it needed to be reasonably calculated in both its means and its substance. So moving to the means requirement of that notice, it needed to be those means that would be akin to those reasonably adopted by someone who was actually trying to get in touch with their intended recipient. So here in this case, Dr. Foster received a single email from Dean Berman. Now, according to the surrounding circumstances, though, we don't know whether in fact that was reasonably calculated. We don't know how much he relied on his email, how much, whether that was his preferred form of contact. And in this particular case, because of the viral nature of his blog post, exactly how much traffic his inbox was receiving at the relevant time.
Wasn't it Mr. Foster's or Dr. Foster's responsibility to provide enough factual basis to survive the motion to dismiss about whether he had received notice?
Yes, Your Honor, and he did in fact plead to this very thing by saying specifically in the complaint that while he did receive an email, its contents were vague and nonspecific and didn't at all afford him of the knowledge that his occupational interest was at stake here. So that actually moves me quite nicely to the substance requirement of the notice that was due here. So the substance needed to be, generally speaking, that which apprises someone of the exact nature of the interest that was at stake here and what the government was thinking about doing. But this court has spoken even more specifically to the notice that's due to someone who is a tenured public employee, as Dr. Foster was. So that person is entitled under this court's decision in Loudermill to three specific things: oral or written notice of the exact charges against him, the nature of the employer's evidence against him, and some notice that he would have an opportunity to tell his side of the story. Now, when we look to the exact language of the email that Dean Berman sent to Dr. Foster, it read verbatim: "You and I need to meet so that we can discuss the recent allegations against you. This is a very serious matter. Please contact me so that we can set up a time." Now, even the most deferential reading of that language does not suggest that Dr. Foster was about to be fired, that the university was about to publish stigmatizing statements against him, or that he would have an opportunity to show up at this hearing and respond. And per this court's very clear precedent in Loudermill and Mennonite, it was incumbent upon the government to tell him explicitly about all of these things. Now, moving back to how the government stigmatized him and revoked his interest in his occupational interest here, the government stigmatized him by publishing documents that both attacked his reputation in a very public manner and that were provably false. So generally speaking, the government stigmatizes a person whenever it lodges a very serious attack against his reputation using statements that can be proven false. Now,
In this case, the idea that his statements were outrageous or insane, meaning outrageous, is not provably false, right?
well, I'll respond to that in two parts, Your Honor. For the first part here, the exact statements that Dr. Foster pointed to in his complaint, namely that he was called insane, incompetent, that he was an embarrassment to the medical profession, that he was saying things that were outrageous, outdated, irresponsible, all of those things are sufficiently plausible under a 12b6 standard in order to withstand a motion to dismiss. Those could be proven false just under that standard. But assuming that we are only taking those statements as mere opinion, it's been this court's contention that even statements that are opinions in their technical form can still contain within them embedded assertions of objective fact that can be proven objectively true or false. Moreover, this court in Bressler has instructed us that we need to take those statements in their entire context and ask ourselves whether a reasonable person could interpret those statements as being capable of being proven true or false. So in fact here, that a statement, any given statement, may either be provably true or false or have that same appearance. So in this particular case, when we view the university's statements in the context of the very authoritative medical field, the speakers who participated in the writing of the letter, we can reasonably infer that Dr. Foster's medical advice being called outrageous, outdated, irresponsible could factually be proven true or false. Moreover, the university, having attached that alumni letter to its press release, says something very important about the perceived truth value of those statements, namely that it relied on those statements in coming to the factual conclusion that Dr. Foster had violated university standards in this case. Now, Dr. Foster did explicitly plead to the fact that despite the university saying that he violated university standards, the university could actually point to no language in any of its policies or procedures that specifically limited, proscribed, or circumscribed the course of conduct that he chose to pursue on his blog. So not only in this case was the government stigmatizing Dr. Foster here through using these statements that were personally and professionally embarrassing to him and had content in it that could be proven false. That's not the extent of where his injuries ended, unfortunately. So the government here also revoked his or interfered with his right as a tenured professor to his continued employment. So at this second stage of the stigma plus case, the plaintiff needs to show that some tangible liberty or property interest was either substantially altered or extinguished by the state. Now, the interest I'm talking about here doesn't necessarily take any rigid or technical form. Rather, it arises out of an existing rule or understanding that's promulgated by the state, either through some contract or statute. So as relevant here, Dr. Foster's interest arose out of his interest in continued employment. That is, his position as assistant professor at the university was a tenured one. And this court held very specifically in Roth, in Sinderman, and in Gilbert that public employees who can be discharged only for cause have a constitutionally protected property interest in their tenure and cannot be fired without due process.
I don't really hear them to quarrel with you on this piece of it. I think their assertion seems to be, and they'll correct me if I'm wrong, that we don't really need to get to this part of the analysis. Am I missing something?
Yes, Your Honor. I just wanted to be thorough in making sure that I covered all parts of the stigma plus test. So because he, in fact, was stigmatized by the government, coupled with this tangible plus factor of his interest in continued employment, he was, in fact, stigmatized by the government in a way that implicated his constitutional interests here and in a way that required the government here to furnish reasonably calculated notice and in a way that it just didn't. And that interest here in reasonably calculated notice was especially crucial to Dr. Foster, given the weight of the interest at stake under Matthews. So Matthews instructs us that we have three things to balance here in deciding exactly how much process was due to Dr. Foster. So first we look to the private interest, then the risk of error versus the value of additional procedure, and then the government's interest. Now this court has held in Loudermill that the government has said that the significance of the private interest in retaining public employment cannot be gainsaid here. Now, one's livelihood is essential to them, and it's especially important to a tenured public professor that their employment interests not be interfered with because of the fear that a university could terminate them for controversial or unorthodox views, as they appear to have done here in this case. Moreover, it's exceedingly difficult for anyone who's been terminated from a job to find new employment, even in the absence of government stigma. Moreover, looking to the risk of error here, the process that was supposed to be afforded to Dr. Foster was supposed to serve as an initial check against mistaken decisions by the government here before any harm was incurred.
What could have been done at a hearing to correct an error? If these were just opinions and there aren't objective facts that are being challenged, what's the purpose of a hearing?
So the purpose of the hearing in this case, Your Honor, was the essential name clearing, namely the both parties' desire here to afford him an opportunity to tell his side of the story about why he engaged in that course of conduct, as well as make sure that he had an opportunity to rebut. Sorry.
Well, I would like you to be more specific. What was he going to rebut? What was he going to offer that could be considered at the hearing and might have changed somebody's mind?
Yes, Your Honor, I understand now. So there could have been at least two different things that he would have addressed in that hearing. First, and probably most importantly here, was the fact that he was accused of having violated university standards when he published his blog post, where in fact neither party could point to any such policy or procedure that prescribed his behavior. So he should have been afforded an opportunity to rebut that alleged violation, as well as clear his name of any assertions that he was insane or that his views were outdated or outrageous. Now, moving to the government's interest here, their interest in efficiency, in fiscal and administrative efficiency, doesn't outweigh any of these concerns.
They say that it's more than that, though, so respond to their contention now that it extends beyond workplace disruption.
Yes, Your Honor, and I see my time is about to elapse. May I respond and then briefly conclude?
Please.
So their interest in efficiency here, number one, has never been explicitly spoken to by this court in their interest in maintaining their reputation. Now, both of them share an interest in avoiding mistaken decisions. And even if they weren't entirely sure if this were a case in which it wasn't possible to afford him good pre-termination notice, at the bare minimum, it owed him post-termination notice or suspension with pay. This court has never held in any single instance that someone with a constitutional interest didn't need any notice or a hearing. So for all of these foregoing reasons, because the government stigmatized Dr. Foster, took away his employment interests, and didn't afford him adequate notice, we respectfully ask that this court affirm.
Thank you, Ms. Bastillo and Mr. O'Connor.
Mr. Chief Justice, and may it please the court. Your Honors, my name is Shane O'Connor, and I represent Dr. Peter Foster in this case. I'm here today because Dragontown University violated Dr. Foster's First Amendment rights. Therefore, I ask this court to affirm the ruling of the 14th Circuit. Dr. Foster's rights, I'm sorry, Your Honor?
No.
Dr. Foster's rights were violated for three reasons. First, his comments satisfied the Garcetti test because they were not made pursuant to his official duties as a medical professor. Second, even if this court decides those comments do not satisfy Garcetti, the speech is still protected because an academic exception applies. And third, Dr. Foster's free speech interest in this case outweighs the interests of Dragontown University.
Your Honors, the first question we have to ask in this case is whether Dr. Foster was speaking as a citizen or speaking as an employee. Now, to that end, Garcetti instructs us the dispositive fact will be whether Dr. Foster was speaking pursuant to his medical duties. Here, he was not. Garcetti did not give us a bright-line rule, and instead stated the proper inquiry is a factual one into what specific duties the employee is actually expected to perform. Now, in reading the Garcetti opinion, we can draw out several factors that the court looked to in conducting its own factual inquiry.
Well, let me just jump in right now. So research, scholarship, and discourse, why doesn't that cover it?
Well, Your Honors, research, scholarship, and discourse related to further the academic mission of the medical school, these are very broad, abstract concepts. They don't go directly to specific tasks expected of university professors. Now, furthermore, we are in the procedural posturing of a 12b6 dismissal, so all reasonable inferences should be drawn in favor of Dr. Foster. It's reasonable to draw an inference here that comments made on a personal website do not fall under any categories of scholarship, research, or discourse.
Even though the comments are discourse about medical treatment and they're delivered, while it's his personal website, it's attached to his university email?
Two things to your point, Your Honors. First, a medical professor should not be expected to not be able to have any comments outside of the workplace about medicine that fall under its professional responsibilities. So the context of this website is very important here. This was not a scholarly website or a scholarly publication. It was very personal in nature. It was the kind of website where Dr. Foster would post pictures of his family and their vacations. Further, the subject matter of the comments themselves actually fall outside the professional responsibilities of Dr. Foster. The record states that Dr. Foster's class he taught every year was on advanced surgical techniques. Now, this indicates that his specialty, his professional responsibility to the university, was on invasive surgery. But by contrast, these comments were about an over-reliance on pharmaceuticals and an over-reliance, specifically on non-invasive techniques. So for the petitioner to make the claim that these comments fall within Dr. Foster's professional responsibilities, more information would have to be added to the record in discovery, which we do not have here because of the 12b6 dismissal. Now, Your Honors, another factor we can look to in the Garcetti opinion is that the speech there owed its very existence to the fact of the speaker's employment. Put differently, the speech never would have been created in the first place but for the individual's job. Now here, Dr. Foster was employed as a medical professor with the university, but his comments do not owe themselves to the fact of his employment. Rather, they owe themselves to his education and knowledge of the medical industry. Now, this is an important distinction to make in this case, and it contrasts sharply with Garcetti. Certainly a memo in a prosecutor's office about an open case never gets written by somebody who's not employed with that office. But here, Dr. Foster could have made the very same comments even if he was not employed with the university. For example, he could have been a practicing doctor in private practice and made the very same comments. He could have been unemployed. He could have been a retired doctor or a retired professor and made the exact same comments. Another way of putting this, Your Honors, actually comes from the Pickering case. The court there ruled that the teacher was speaking as a citizen rather than an employee, in part because the fact of the teacher's employment was only tangentially and insubstantially related to the speech. Now, that's the same thing as here. Dr. Foster's employment was only tangentially and insubstantially related. Rather, it was his education and knowledge that was directly related.
Well, let's move to Pickering then. So assume you're right about Garcetti, and we're in the world of Pickering. Why should your client win under Pickering?
Now, Your Honors, as you mentioned during my opposing counsel's argument, the courts in analyzing the balancing portion of Pickering conduct test have consistently focused on the effect of the speech on workplace relationships. This came up not only in Pickering, but also in Connick. Now, that was a case where the balancing test tipped in favor of the employer. The speech at issue there was a questionnaire circulated by the plaintiff that seemed to provoke her coworkers into being critical of management. The court stated that the employer had a right to punish the employee for acting destructive towards workplace relationships. It stated that the employee did not have a constitutional right to an employee grievance. Now here, Dr. Foster's comments actually caused less workplace disruption, even less workplace disruption than the comments in Pickering. Here, Dr. Foster was not critical of any of his coworkers. He was not critical of his superiors. He was not specifically critical of Dragontown University whatsoever. In fact, the record indicates that Dr. Foster's colleagues already knew about his atypical beliefs. but this still was not disruptive towards the workplace relationships.
Opposing counsel says that you're too focused on workplace disruption. Respond to that, please.
Yes, Your Honor. The petitioner does point to evidence of a reputational harm suffered by the university, and the respondent does not contend that there was no reputational harm. Now, 2 points, Your Honor. First, for this court to accept that evidence, to carry the petitioner's burden in this matter, that would represent a change of direction in this court. That's something that this court does not take lightly. But secondly, the substance of the evidence pointed to by the petitioner itself actually falls short of carrying its burden here. Again, we are in the posturing of a 12b6 dismissal, and all reasonable inferences must be drawn in favor of Dr. Foster. So with that in mind, we turn to the sit-in and the class cancellation.
Well, let's not go there yet. Let's stay with, assume for the moment that we're willing to reach their assertion that there's a pedagogic interest, there's this concern about the community's trust in a medical school. Respond to those concerns. Why aren't those very legitimate concerns that arguably outweigh your clients?
And yes, Your Honor, and of course they are legitimate concerns. But again, 2 points. First, there is no evidence of the record that goes towards that. So it is not just for a 12b6 dismissal to go against Dr. Foster without the evidence.
You say it's not in the record. The record indicates that there's no medical support for what your client said. For a doctor to say something, actually give advice, for which there's no scientific support, that would affect the reputation of the institution that continues to employ that physician, wouldn't it?
Perhaps, Your Honor.
Almost certainly.
Well, universities also pride themselves in fostering a community where individuals can debate ideas on either side of the aisle. So presumably, Dragontown University does have an interest in fostering that sort of community as well. Now, Dr. Foster's comments, while his colleagues in the medical community has stated that they're incorrect, that actually highlights the fact that there is value to those comments. They led to a discourse. The comments online actually went viral even before the medical malpractice case here. They were viewed over 50,000 times, and a rigorous debate took place in the comments section.
Well, what if he were teaching the students that? Would that change the calculus in your view? That would lead to a debate.
Perhaps, Your Honor, that would
But
go...
that would pretty much destroy the reputation of the school, would it not?
Yeah, so 2 points there. First of all, that would certainly fall under the Garcetti rule of falling pursuant to an individual's official duties.
So you're arguing there's an academic freedom exception to that, I assume, and I'm not sure that Garcetti should apply in the academy. So
I'm not sure I understand the question.
Well, you're suggesting that if he taught that in the classroom, then it wouldn't be protected under Garcetti. I'm saying I'm not so sure that Garcetti would apply even then. Just stick with the Pickering analysis for now. Excuse me. Under the Pickering analysis, how would you calculate the balance if your client had been teaching this in a course?
I see, Your Honors. Now, certainly, if Dr. Foster was teaching these concepts in a course, these unproven comments, that would have been more disruptive toward Dragontown University. That would have caused more harm. So the balancing test may tip in favor of the university in that sort of environment. But that's not what we're talking about here. We're talking about comments that were posted on Dr. Foster's personal website. The record indicates that this was never taught towards the students. Now, Your Honors, it's important to remember, of course, that the Pickering and Connick test is, in fact, a balancing test. It's not simply an opportunity for the employer to point to workplace disruptions and potential harms. Now, to illustrate this fact, I turn to the 1987 case Rankin v. McPherson. The speech at issue there was an employee speaking to a coworker and stated she hoped that if President Ronald Reagan was shot a second time, he would die. Certainly, such blunt and morbid comments about the President of the United States could cause serious harm within the workplace. And yet the court still sided with the plaintiff there because those comments did not rise to the level of tipping the balancing test in favor of the employer. As this court stated in Waters v. Churchill, Your Honors, the First Amendment reflects the profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open.
Well, if I'm remembering correctly, part of the issue in Rankin is that, perhaps inartfully expressed, the employee was expressing an opinion on a political question. What First Amendment interests does your client have in expressing false medical statements?
Your Honor, Dr. Foster was contributing to an ongoing debate about public health, how best to approach epilepsy, and the treatment of it. Now, this court should not concern itself with whether or not Dr. Foster's comments were correct, despite the scientific consensus. To be sure, human history is littered with examples where new assertions were put forward that were initially rejected by the mainstream thinking and yet were later proved to be true. Now, it's also true that many of the classic examples come from a bygone era. Copernicus, Galileo, these are individuals that were living in an era dominated by an unquestioned church dogma. We don't live in that sort of society anymore. But we do live in an era with a reactionary culture. And we saw how that played out in Dr. Foster's case. He was fired because of an instant reactionary backlash from the public because of Dr. Woolley's medical malpractice case and her testimony about Dr. Foster.
In your view, if a teaching hospital had an academic on staff who was repeatedly blogging on a private blog about things that the medical community had pretty uniformly rejected and found to be not only incorrect but unsafe, would the hospital have no recourse?
It certainly would have recourse, Your Honors, but there's an important factual distinction in your hypothetical there. An individual or a nurse employed with a hospital would be directly responsible for treating patients. Now, that would cause serious concern amongst the public and would cause huge doubts about individuals wanting to go to that hospital.
Do we know that Mr. Foster didn't see patients? I don't recall.
That's correct, Your Honor. In the record, it indicates that Dr. Foster never met the individual who died in this case. He never spoke with Dr.
But
Woolley.
did he ever see patients?
That's not in the record, Your Honor. So because Dr. Foster's comments went more towards the other academic community, talking to doctors directly rather than dealing with patients, it's a much different scenario than the hypothetical presented by yourself.
Well, isn't the magnitude of the harm suffered by the university exacerbated by the fact that there was a death here? And shouldn't that, does it matter that there was a death?
Your Honor, that goes back to my point when answering Justice Hart's question. To hold Dr. Foster accountable for the death here would be incorrect and unjust. Dr. Woolley was responsible for that death. Dr. Woolley never consulted with Dr. Foster. Dr. Foster never met this individual. He did not know the specifics about this individual's condition. So Dr. Foster, he was contributing to public debate. Now, that's not a dangerous proposition.
Wasn't he directing doctors to use fewer pharmaceuticals and instead take other treatments?
Yes, Your Honor, that was his contention. However, the Post also stated that if doctors did not want to do that, they were still obligated to debate the issues and give it a fair shake. So, Your Honors, I see my time is running short. Again, because Dr. Foster's comments satisfy the Garcetti rule or fall under an academic exception, and because his interests outweigh the interests of the university here, his First Amendment rights were violated. Therefore, I ask this court once again to affirm the ruling of the 14th Circuit.
Thank you, Mr. O'Connor. In rebuttal argument, Mr. Kervin.
Your Honors, the 14th Amendment protects against the deprivation of life, liberty, and property. Now, in its argument, Respondent talked a lot about Loudermill and the notice needed in that case. Loudermill is a case that arose as a property interest, not a liberty interest. In the terms of this complaint, Dr. Foster did not plead that Dragontown University deprived him of his property interest and continued tenure. He pleaded that Dragontown University deprived him of his liberty interest and his reputation.
Is there a lower hearing standard or notice standard for protection of a liberty interest than a property interest?
This court hasn't exactly defined what sort of notice is necessary. Now, what this court has said is a name in Codd versus Velger is that the hearing only needs to offer the employee a chance to clear his name. Now, the circuit courts have also said that these sorts of hearings do not need to follow any sort of formal procedures. They can be informal. Arguably, the notice requirement could be informal as well. Now, turning to the value of a hearing, the respondent brought up the Matthews balancing test. Now, one important thing to consider in that balancing test is the risk of an erroneous deprivation. Without pleading that, or without alleging that any of the evidence or opinions were false, there really is no value for a hearing. And arguably as well, Dr. Foster's reputation was more damaged by his own actions in writing on the blog and the subsequent trial that resulted from that. Now, the Third Circuit, for example, in Graham, held that a criminal trial.
You're saying that the plaintiff must plead in anticipation of a defense of truth? That the plaintiff has to allege that these very damaging statements were false, as opposed to the defendant saying we're not liable because what we said was true?
I see I'm out of time, Your Honor. May I answer your question?
Have to ask the chief.
Go ahead.
So the Second Circuit has pleaded, or has held, that the plaintiff doesn't need to raise or doesn't need to prove the statements are false at the 12b6 stage, that the plaintiff only needs to raise the issue of falsity, and that wasn't done here. So following the holding in Codd versus Velger, if there's no allegation of false, that these allegations were false, what's the purpose of a hearing? For Dr. Foster to continue his one-man crusade against modern medicine? He can do that through his blog. He can do that through other means. So for the aforementioned reasons, Your Honor, Dragontown University respectfully requests that this court reverse the 14th Circuit.
Thank you, Ms. Regan-Smith.
I'd like to address just one point, Your Honors. Respondent indicated that there may be an academic exception to the Garcetti doctrine. There are several reasons to believe that the First Amendment does not compel such an exception. The first is that it's not at all clear why the First Amendment would protect the speech of academics and not the speech of other government employees that serve similar purposes. So it's not.
Let me suggest something. Garcetti says it's not, speech isn't protected if it's pursuant to job duties. What if your job duty is to foster debate? What if the purpose of an academic institution is the free flow of ideas? So there's no such thing as saying something contrary to the interest of the institution in that context.
So I think the same could be said in the context of Garcetti, that the type of speech that we would want to encourage a district attorney to engage in would be notifying the Department of Police misconduct. That's roughly analogous, I think, to the scenario that you've outlined. In that case, the court was satisfied that whistleblower statutes were sufficient to protect the speech interests of those employees and of the public at large. There's no reason to think that the same can't be said here of tenure, that tenure is adequate to protect the public's interest in debate among academics without constitutionalizing employee grievances, which is my second point, which is that basically every employment decision that a university makes depends on the speech of its professors. So every decision to deny tenure, every decision to pass over a professor for a promotion could be challenged as a First Amendment violation. In conclusion, the university respectfully requests that this court find that Dr. Foster's speech is not protected by the First Amendment, and that as a result, the complaint failed to state a cause of action under which relief could be granted. Thank you.
Thank you. And I believe we're done. So. We're going to retire to deliberate, and I gather we'll be back with you very soon.
All rise.
I think that's, and then we comment and so on. That's the way I've done it in the past, because I haven't done it here before. Hope I didn't screw you up. Is that what we do? We come back and announce the winner?
Yeah, winning side and best oralist. Okay. I apologize for the mix-up. Nobody told me who the chief was, and they had part of it.
Oh, that's all right. I talked to Chris about it. It's not I've always wanted to be Melissa Hart anyway. So.
Don't we all? So, yeah. Winning side, best oralist.
All right, if I could have everybody's attention, if you would please just have a seat. All right, thank you, each and every one of you, for being here. If you would, again, just join me in congratulating the competitors for a really incredible. My name is Chris McKee. I'm the Director of Experiential Learning. Student competitions like Moot Court and Mock Trial and transactional competitions fall under the umbrella of experiential opportunities for students to have simulated experiences like arguing before Supreme Court justices and 10th Circuit justices or judges. And it is always an honor each year to have the Rothgerber competition go through these early rounds in which the competitors hone their skills and then have this opportunity to be here today to argue before real live justices and a judge from the 10th Circuit. How many 1Ls are in the room? All right. So the class of 2020. Thank you for being here. I hope that you have noticed that 3 of the competitors here are 2Ls. And so just imagine where you are right now in legal writing, where you are right now in your 1L curriculum of you being and standing here February or March of next year and having this same opportunity, arguing before justices and a judge from the 10th Circuit. There is a long way that you go from the time that you're a 1L to the time that you are 2Ls or a 3L. And these opportunities really do serve, I think, these speak well of these students, and I think also serve the whole entire law school with some honor that they have worked so hard. One of the great things I think about the Rothgerber competition are that students in the Moot Court part of Barristers Council help run this competition. They help select the problem. They help run the early rounds. And Josiah Beamish, our bailiff, deserves that round of applause because he was the chair of this competition this year. And so essentially since December has been devoted to not only his schoolwork, but also running this competition. And as you heard from Dean Anaya, it had 24 competitors that began in early rounds. There were briefs that were done after the finalists were then selected. They had to change issues, some of them. Some had to change sides. And switch that up and get briefs due and turned in by Sunday of this past week so that the judges could have those. So it's an incredible amount of work. But hopefully each would say that it was worth it. We usually, as the judges are deliberating to announce best oralist and winning side, we usually do open it up for a couple questions to the competitors if anybody has a question for them. The question is, who argued off brief? All 3 of you had to switch. So 3 of the 4 had to either switch up issue or side. Okay. Any other questions? Yes.
How many hours a week did you devote to this leading up to the competition? You're almost done. Yeah, definitely do it next year.
Can we count it in days instead of hours?
Right, so now they'll have tons of time for the rest of the semester now that they can switch gears back to their coursework. Other questions? How many people here, prior to coming to law school, had experience in mock trial or even moot court of doing an argument like this, which is very different than mock trial? How many students? All right, a couple hands. We tend to find students are coming into law school with a little more experience than perhaps in the past you would have expected. But I think by the show of hands, I think you see that most of the law students, when they walk into the building, need to learn these skills. These skills aren't, innate necessarily, and they're not skills that they came into law school with. And so the learning curve is great and steep for everyone, but you have these great opportunities like student competitions, like moot court, mock trial, and transactional, in which you have these opportunities to get on your feet, argue these cases, learn the cases, and then communicate them through oral argument. Tomorrow, if anybody's in the building, we're hosting the Law Meets Transactional Regional Competition. There are law students coming from Hawaii. Hopefully they will make it in tonight on the airplane. I hear it's snowing in Denver, but we have students coming from Duke, from New York State. So there will be 12 teams competing in the Law Meets competition. Colorado has had a great run at winning the national law meets, and we have 3 teams in other regions competing tomorrow. They all were leaving today to go to other regions to compete in this transactional competition. So there are opportunities for everybody to be able to find the kind of competition or area that they may want to argue. How many of the finalists want to do appellate argument as a career?
Give me a few days to think about it. I'm still recovering.
Is there anything that helped? I know Hannah has clerked for appellate courts. Is there anything that helped, I guess, get you to where you are today, beyond just grit and working, but other experiences that you've had that helped you, I guess, for preparing for oral argument?
Well, I was one of those people that did mock trial and moot court in undergrad, so that's how I spent, I think, most of my time. So while this experience wasn't entirely new to me, I think the caliber of it was. And I think just the law school experience generally has prepared me for this, especially legal writing, where you would be expected to, produce a brief similar to what we had to and argue in front of your legal writing professor. It's much the same.
Wonderful plug for legal writing. I know most people are here because of legal writing and your professors encouraging your attendance here. So thank you to the legal writing faculty for that. And I think the legal writing faculty does get a lot of credit for producing some of the quality that you saw here today. How about clerkships? Others that have had opportunities for appellate? How many have you gone to observe arguments in order to hone the skills?
Yeah, I got to see some arguments at the Colorado Supreme Court last year, and I think that's a huge help because it takes away a lot of the nerves. You see that lawyers who do this as a career, they're up there getting confused by questions, they lose track of where they are in their argument, they stutter sometimes. I mean, you just can't be perfect for 15 minutes straight. So it's just, I don't know. It takes away some of the nerves, for sure.
Others?
I mean, I think the best way to prepare for me is to engage with, because I don't have any appellate experience. I saw one argument at the Supreme Court, but it's to engage with my classmates who worked on the issue a lot. I found a ton of stuff off Rachel and my family. It's really helpful to run legal arguments by people who don't have a legal background because they can tell you if it's nonsense. If it doesn't make sense in plain English, then it's not a good argument. But I think the more engaged with the material you are, the more coherent it all comes out in the end.
Yeah.
I don't have really anything to add to that other than if you want to do this, the only way that you're going to get better at it is just to do it. I mean, I used to be an instructor at Indiana University, and some of the best advice I got was from a guy who'd been lecturing for 30 years, and he said, I don't think I'm a good lecturer. I won't say that, but I will say that I'm better now than I was 30 years ago. So that, really made me, think that, this is just something that you do. It's just something that the only way that you're going to get better at is to do it. Certainly, I think watching other people helps too, but if this is something that you want to try, just go for it. And, you know, if any of us can do this, you can do it too. So that's my advice.
And so this is, as the dean said, our sort of premier moot court internal competition. We also, as the program highlights, have a lot of external competitions where we send teams, like we're sending the transactional law meets participants. But in moot court is really one of our largest parts of Barristers Council. And we send students all over the country to compete in everything from space law, moot court, arguments to the telecom communications moot court argument. And so of the participants that are here, has anybody represented the school in an external competition yet or preparing to?
Well, my career is almost over, so the answer to that would be
no. Which I think actually is also shows that you can also focus and work hard on the internal competition here. There's also the other internal competition is the CAC competition, the Colorado Appellate Advocacy competition. So those who are the one else who raised your hand, that is something that happens in the fall. And so in the fall, I think this year, how many competed?
We probably had 25-ish teams, so probably like 50 people. Yeah, it was a lot.
So we've had anywhere between 50 and 75, 76 or so students compete in CAC because that is one of sort of the prerequisites to represent the law school in moot court competitions externally. And so you will get a chance to work on a brief and then go through rounds of oral argument. And that usually helps prepare anybody who is thinking and considering competing in the Rothgerber competition. So immediately following when the justices come out and give their verdicts on best oralist and best side, we invite everybody here to join us in the Rothgerber reading room in the library. So those actually, when we first sort of started doing the Rothgerber and the tradition of multiple rounds and having as many people attend. There were those of us who had never even been to the Rothgerber reading room. It is on the second, you go to the second floor and you walk down one floor, and there's a huge plaque that has the names of all of the Rothgerber finalists who have argued for the past,
I think it was 1950, I think it goes back.
Right. And there is the Austin Cup for the best oralist, and you'll see some of the names engraved there with some of the individuals in this room from the last couple of years who came back today to join us as alumni. So I hope that everybody stays for both what the justices are going to return and also for the reception. And we can check on the justices, see how they're doing. Or not, just ask.
Good. All rise.
Thank you. Please be seated.
My glasses.
You got them? Okay, good. So, as the Chief Justice of our imaginary court, it's my privilege to announce the winners of the competition and the best oralist, and then we'll share some additional remarks. We'll then take the more sensible course of having my more experienced colleague, now Justice Hartz, or Harris, rather. No, Hartz. Harris Hartz.
Colleagues I've sat with colleagues for 17 years who still call me Judge Harris.
Yeah. So first, drum roll, please. The petitioners have won the competition. And it may come as small consolation, but I should let you know that it was not an easy decision because we thought that all of the advocates really did a remarkable job. So let's give them all a round of applause. So now the best oralist, and that goes to Ms. Regan Smith.
Justice Hartz. Not to be confused with Justice Harris.
Or Justice Hart.
Yeah.
I've done quite a few of these, and the standard thing to say is we would love to have people of your caliber appear in our court. But I don't think that's appropriate here. That's too low a standard. You guys were really good, really good. It's rare to have that quality of argument by anyone in the law schools where I've done moot courts, a lot of them. What I particularly loved, and every judge loves, you guys reeked of preparation. You just... I said preparation.
Not perspiration.
You knew your stuff. You were prepared. Didn't always agree with you. That's never going to be the case, but you were prepared and you responded, and it's just such a pleasure to see that. You would be welcome in my court, by the way, but the only criticism, I guess, I'd have, and it's unfair because this is not your typical argument where you're just trying to win your case. You have your positions that you need to articulate and say here. But when you're in court, you want to go with the flow. And you don't want to make an argument that the other, you don't need to respond to something the other side never said, or that the court doesn't ask you about. And if the court asks the question, then answer it then. One interview I read a few years ago was with Chief Justice Roberts, who is considered the best oral advocate before the Supreme Court before he became a justice. And he said he wrote down all his points on file cards and then shuffled them so that whatever order the Supreme Court justices asked questions, he could transition to the points he wanted to make smoothly. Can you imagine how much preparation that would take? But it's an impossible task, really, but that's important to go with the flow. I learned that perhaps my very first oral argument as an attorney before the 10th Circuit. I was an assistant U.S. attorney at the time, and I started addressing something in the brief about an evidence issue, and after 3 or 4 minutes, it seemed like the presiding judge said, "Now, Mr. Hartz, your opposing counsel didn't press that point at argument here today, did he?" And I said, "No, Your Honor." And he said, "Then maybe you should quit digging yourself a hole." I wanted to say something about the subject matter of this case because it's so important to me, and I think important to the country these days. And I'll start with a story from my freshman year in college. The young Democrats at the school had a vigorous debate and decided to invite as a speaker Governor George Wallace of Alabama. At that time, this was in 63, 64, he was probably the most evil public figure in the country. He was the face of segregation, now and forever. You couldn't ask for a worse person to come. But he was invited, and I attended. And it was one of the most, if not the most, educational experiences I had in college, because he was smart, he was very articulate, he was witty, and I learned that you can't tell from those characteristics whether someone is evil or not. And that's something you don't learn from movies and TV when you can tell who the villain is by the sneer on the face and all that. So I was very grateful to have had that opportunity to learn that early. And I unfortunately continue to relearn it. I wrote about that in my reunion report a year ago, and what an important experience it had been for me. One of my friends from college, who was 2 years ahead of me, sent me a letter because he was involved in the invitation. He said the dean of students had called him in and essentially threatened to flunk him out if the invitation went through. He took it as an empty threat, which it turned out to be. That friend later became the chief judge of the Sixth Circuit Court of Appeals. So free speech, and particularly free speech on campus, is so important. And what makes this hypothetical so hard is, gosh, this really is an awful thing to say, and it would be harmful to the medical school to have someone distributing this sort of information. And that's why it makes you think, should we treat it the same way we treat First Amendment issues elsewhere, which is you can say it whether it's true or not, you're protected. And right now we probably defer to universities to some extent, but maybe universities will prove that they shouldn't be allowed to decide what's true or false among the statements of their faculty members. Anyway, it's a matter of significant debate, and maybe some of my questions indicated my concern about whether universities should be deciding whether what a faculty member says is true or not. But you couldn't have picked a harder hypothetical to say that the university shouldn't have been allowed to do it. Well, maybe that's a sour note. I don't mean to have a sour note, because this was a very uplifting experience for me, and thank all of you for being so well prepared and giving me faith in the future of the appellate bar. So,
Justice Hart.
Sure. You were all amazing. I mean, I have 4 whole days of oral arguments under my belt, and you were.
She's crushing it, by the way.
I can think of a couple of lawyers who were as good as you, but only a couple. For all 4 of you, really, that was remarkable. The things that really stood out to me, you were so good at answering questions. I think, Heather, that really stood out for you, but honestly, I think all 4 of you were so good at answering questions. Your facility with the case law, and actually, Alex, that to me, you stood out in that regard, that you clearly knew all of the cases so well, and that was really remarkable. I thought all of you had, at different points, all of you had very nice openings, but you also had, you had clearly sort of thought about the themes for your arguments, and so at different points throughout the arguments, there were sort of turns of phrase that I could tell had become part of sort of the big picture idea that you had about the case, and that you sort of stuck with that in ways that I thought made the arguments all really compelling. So I was blown away.
Well, I thought you all were terrible. No, actually, I think that all of you, 2 of 1, I mean, you were just so remarkably poised. I mean, I can't imagine doing this even now without showing some nervousness, especially in the face of difficult questions, and let alone having, exhibited the kind of poise that all of you did today when you're getting bombarded with questions from folks like us. So, it's just very impressive, very impressive. And so I think just sort of echo one of the observations that Justice Hart just made, that Ms. Regan-Smith was particularly responsive to questions. You know, what comes to mind, one of the things we talked about was the stolen valor question, and how you just were completely prepared for that, locked in, answered it so directly. I thought that that's an excellent example of why it is that you've been anointed as the best oralist. But all of you, as has been said a couple of times now, were very responsive to the questions, and that was much appreciated. And sort of apropos of the George Wallace comments, I don't know that I'm anxious to lump her in with George Wallace, but there's Amy Waxman is a UPenn law professor who's, was co-authored a very controversial piece last summer with a San Diego law professor, and it was sort of, arguing against the value of multiculturalism, I guess would be the way of putting it succinctly. And this weekend, there was an op-ed piece in the Wall Street Journal that I came across just as I was thinking about all this academic freedom stuff in the context of Garcetti and your arguments. I thought it was interesting to read Professor Waxman's piece about the importance of engaging even those with whom we disagree, particularly in the university setting, at a substantive level rather than just hurling labels at each other, and how important it is for us to be able to argue with the people who even are engaged in advancing what we consider to be fringe beliefs or things that are despicable. It becomes difficult sometimes for us to decide when it becomes hate speech, and we'll have to struggle with that at times, but I think typically we do better to err in favor of allowing people to exchange ideas and engaging at that level. So I don't mean to get too preachy about this, but as long as we're talking about the value of academic freedom, I guess I just want to echo some of the earlier observations about that. And so I guess I'll conclude it by saying, once again, thank you all for excellent work today.
Got to come down and shake their hands now.
Thank you. We will all just reconvene in the for the reception in the library. If we please can go there, and then we'll have the competitors take pictures. There you go.